So I will also request everyone to kindly keep the mics on mute. We'll have a question and answer session towards the end of it, or if ma'am wants an interaction, then she'll ask in the middle. So otherwise, sometimes it just there are some noises at the back. So, hello and very warm welcome to everyone. We welcome you once again to another class of Vestralex free online community classes on law. This is a free legal literacy initiative for you, by you, and possible only through the generous contribution of our seniors. We are in the fourth year of this initiative right now, and we've been blessed by a lot of advocates, senior advocates, members of the bar bench, and professors of law. So today we have one such opportunity of learning from an esteemed professor in law. Her name is Dr. Daksha Sharma. She has taken the time out to graciously extend to us her knowledge on the topic of law of adoption in private international law. So I think this will primarily be covering the South Asian aspect of this. But rest, I'll just briefly introduce Daksha ma'am and have the class. So Dr. Daksha Sharma, she is an assistant professor of law at Faculty of Legal Studies, South Asian University. She is presently working as an assistant professor of law and is also an arbitrator at Prasar Bharati, New Delhi. She is frequently invited to lecture on constitutional law, ADR, international law, human rights, and environmental law at prestigious institutions such as the Indian Institute of Law and Delhi Police Academy. With over a decade of experience in both the law and academia, Dr. Sharma has been recognized with several awards, including the fifth Dr. Sarojini Naidu, the Nightingale of India Award in 2021, and the Global Peace Award in 2022. She holds a PhD in international law and has specialized qualifications in mergers and acquisitions law, in international environmental law, intellectual property rights. She's also a prolific author and has variously published uh, in renowned journals and contributes to media as a legal expert. Daksha ma'am, it's a blessing to have this opportunity to learn from you today, and we welcome you with folded arms. And ma'am, thank you so much. I request you to kindly take the class forward. Also, ma'am, I'll request you to kindly just guide me with respect to when I should start the presentation and when I should, change the slides. So, very warm
Sure.
welcome.
First of all, I would like to thank Advocate Keshav for introducing me. And I'm extremely grateful to your esteemed organization for organizing this talk. And this topic is extremely important, as we all are aware. And I think it's going to be a wonderful opportunity to interact with all who are present. And as it is uh, as the process is streamlined, we are going to see that what challenges we have and how we can overcome it. So again, it's my pleasure to be here and to interact with the wonderful audience who are present. So thank you for giving me this opportunity. With this, we would like to move to the first portion of our discussion on inter-country adoption and how it can be streamlined, what are the problems which we are facing, what are the issues, and how it is occupying an important space in litigation. So I request you to please share the PPT.
Is it visible?
Yes, it is visible. This is the outline of the lecture which I have prepared. And as the topic suggests that it is intercountry adoption under private international law from South Asian perspective. So we have to see that how the concept of adoption has grown over a period of time and what are the divergent aspects of intercountry adoption. So we are going to talk about concept of adoption, meaning and definition of adoption, then common concerns related to international adoptions, then common questions and the issues revolving around this particular topic in the context of theory as well as practice. And then we will deal with the Indian scenario for adoption. And then in the later part, we will discuss about the South Asian perspective, the practice which is prevalent in other South Asian countries. And then we will move to conclusion and suggestions, followed by question and answers. So this is the outline of the lecture which I have prepared. And I believe that, the lecture is really not complete until and unless I receive questions and participation from the audience. So I request all the participants to ask the questions and to raise their issues and concerns with respect to this particular topic. So with this, we can move towards the first slide. So as the first slide suggests, that this is the introduction to the concept of adoption under private international law. So we will be dealing with this aspect, that what adoption is. As far as adoption is concerned, we know that adoption is transplanting the child from biological family to the adoptive parent's family. So when we say this is the normal context of adoption. But adoption has a greater significance, because when we talk about adoption, it is not only the adoption of the child which is transferred to one family to the other family, but it also covers those children who are orphaned, abandoned, and surrendered. With Hague Convention, process has been streamlined and it has been simplified as far as transplantation of children is concerned, adoption is concerned, international adoption is concerned. But I believe that there is a requirement that the domestic laws should also reflect the aspect of Hague Convention in their respective legislations. And I believe that this is the need of the hour. So as the concept suggests, that adoption is all about providing home to the homeless and child to the childless. It is based on private international law, the Hague Convention, the UN Declaration on Social and Legal Principles relating to adoption and foster placement of children nationally and internationally. In 1986, this declaration was formulated, accepted. And then we have Convention on the Rights of the Child, 1989, and also the Hague Convention of 1993 on adoption, particularly international intercountry adoption. Now, with these documents, international adoption has been recognized and legitimized. So therefore, when we talk about adoption, it would be wrong if we are looking at the entire process with domestic angle, because it is coming into place from the international conventions and declarations. So therefore, the revolving issues with respect to adoption are child abduction, trafficking, promoting best interest of the child, protection of child against trafficking, related aspects of immigration and citizenship. All these concepts become important. So, as we are dealing with these cases in the courts, we have to keep in mind that, how these issues have to be sorted, because adoption is not only signing and submission of adoption deed. It has much more relevant aspects connected to it, like citizenship, immigration, and how this can be sorted when we are talking about international or intercountry adoption, because various jurisdictions are involved, various domestic legislations are involved. So we have to see that how we are looking at this particular aspect. I request you to please change the slide. Now, the problem related to adoption is becoming more intense, because there are two sets of countries. If we broadly look into the aspect of intercountry adoption, one is that category of countries which have lower birth rate and small number of children available for adoption. Second category is of those countries which have higher birth rate and more number of children available for adoption. So therefore, there is a disparity between the availability of the children and the families which are willing to adopt those children. And we have to sort out that disparity, because as we see here that, developing countries have more children who are in the category of orphan, abandoned and surrendered children. And therefore, these children are looking for the family atmosphere, for the home wherein they can grow well. So when we are talking about international adoption, we have to keep in mind the existing disparities which exist in the present scenario. Moving further, what is the concept of adoption? When we talk about adoption, as simply, we know that adoption is transplanting child from one family to another family, or from other categories to the home, from adoptive parents, like from biological parents to the adoptive parents. So therefore, we have to see that when we are talking about inter-country adoption, essentially, we are focusing on nationality and residence. So therefore, domestic adoption is different from international adoption, because in domestic adoption, we are not concerned about nationality and residence. But here in inter-country adoption, immigration, citizenship, residence, all these concepts become extremely important, and how the process is happening, because we know that at times the process may be abused, may be misused, and therefore a stringent mechanism is required to be introduced so that we can deal with the problems and issues related to international adoption, particularly child trafficking and well-being of the child has to be ensured. Best interest of the child is to be protected. So when we are talking about inter-country adoption, it is certainly an increasingly common form of family adoption, and it is accepted globally. And this term suggests that adoption is the system in which adopters and the child do not have the same nationality and habitual residence. So therefore, different residence as well as nationality is introduced in the case of international adoption. So definitely we are talking about foreign jurisdictions in case of international adoption, but same concept is not introduced in domestic adoption. So for international adoption, we have Hague Conference on Private International Law, which is specifically dealing with the aspects of intercountry adoption in the Convention on Protection of Children and Cooperation in respect of intercountry adoption, 1993. All those countries which are party to it, which have ratified, they have already introduced the significant aspects of this convention into their domestic legislations. I request you to please change the slide. Now coming to the common concerns. So I have highlighted few common concerns with respect to international adoption. One is opportunity to grow and develop within loving families. So it is not about sending the child to some other family, or it is not about placing the child in some home. It is more about whether proper care is extended to the adopted child or not. Then, of course, requirement of stringent internal laws, as in domestic laws and policies, should be there to regulate the inter-country adoption practices. If the laws are not stringent, then certainly it will lead to the misuse and abuse of the process. Protection of best interest of the child. This is the norm and philosophy for inter-country adoption, not only in India, but across the globe. So therefore, even if you see the landmark judgments in adoption, for example, Lakshmikant Pandey versus Union of India, AIR 1984, you would find that in that judgment also, Honorable Supreme Court has reiterated that there is a requirement to protect the best interest of the child in every case. So therefore, in all the cases related to adoption, the thrust of the judgment is that court should protect the best interest of the child while deliberating on the related aspects. So therefore, all these judgments are revolving around the philosophy that the paramount consideration for giving the judgments in favor or in against of the child is protecting the best interest of the child, where the child will be happy, where the well-being of the child will be restored. So this is an important aspect of international adoption. Other allied concepts you can see related to child trafficking, related to citizenship, post-adoption follow-up, property rights, child abduction has to be seen in the light of adoption. Next is common questions related to adoption, not only international adoption, but also domestic adoption. So, the first aspect is that whether there is a need of enacting special legislation on inter-country adoption in all the countries so that we can deal with the problem of child trafficking and the process becomes streamlined. Second aspect, whether the principle of subsidiarity should be given prime importance while placing the child for inter-country adoption. Third, whether it is viable to give the child in inter-country adoption to the same-sex parents, transgender and live-in relationship couples. Fourth, whether there is a need to have a policy and legal mechanism for openness in adoption records. And fifth question, whether the adoption laws are in coherence with the international law, particularly UN declarations and Hague Convention on Inter-Country Adoption 1993. So these are the common questions which I formulated for the perspective of this lecture. Of course, there are more questions which can be deliberated upon, which can be further reconsidered in order to improve the practice of international adoption as well as domestic adoption. Now, moving to the Indian scenario. So I'm not going to go much in detail, but I would like to highlight a few perspectives related to adoption in India. As far as adoption is concerned, we have two legislations. One is Hindu Adoption and Maintenance Act 1956. And the other legislation is Juvenile Justice, Care and Protection of Children Act 2015. As far as HAMA is concerned, it is only related to Hindus, and Hindus are defined under Hindu Adoption and Maintenance Act 1956. But coming to Juvenile Justice, Care and Protection of Children Act 2015, we know that it is open for all. The legislation applies to all the religions, not only Hindus. So therefore, there have been views that JJ Act 2015 is a step towards Uniform Civil Code, because we know that HAMA has its own limitation. It is only applicable to Hindus. But when we are talking about Juvenile Justice, Care and Protection Act of 2015, it is applicable to all the religions. So therefore, it is suggested that this is this legislation is in the direction of Uniform Civil Code, which is again coming under the directive principle, Article 44 of the Indian Constitution. So again, when we are looking at adoption, there is a necessity to look at this topic from transdisciplinary, interdisciplinary, intradisciplinary, and comparative perspectives, because there are so many aspects attached to adoption: the sociological view, the philosophical view, the religious view, the psychological view, because we are dealing with adoption of children and how child psychology works if he or she is placed in the wrong family, and how child is behaving when he or she is placed at the right position. So all these aspects become extremely important. So I believe that it is one such interesting topic which has a multidimensional approach, and it should be studied from transdisciplinary and interdisciplinary perspective. So coming to the sections which are mentioned under Hindu Adoption and Maintenance Act. So as per Section 5, it is quite clear that adoption is to be regulated by the provisions of this Act of 1956. Section 6 is talking about some of the important elements for valid adoption. For example, the person adopting has the capacity and also the right to take an adoption. Also, the person giving an adoption should have the capacity to do so. The person who is adopted should be capable of being taken in adoption, which means that even the child who is given in adoption should fulfill some eligibility criteria. And also the adoption should be made in compliance with the other conditions as mentioned in this chapter. Coming to Section 7, capacity of a male Hindu to take an adoption. So any male Hindu who is of sound mind and is not a minor has the capacity to take a son or a daughter in adoption, provided that if he has a wife living, he shall not adopt except with the consent of his wife, unless the wife has completely and finally renounced the world, or has ceased to be a Hindu, or has been declared by the court of competent jurisdiction to be of unsound mind. So these sections have been amended by the Amendment Act, Section 7, Section 8, and they have introduced the new perspectives to adoption law. Like as you see here, Section 8, it is talking about capacity of a female Hindu to take an adoption. So now, any female Hindu who is of sound mind, not a minor, and has the capacity to take the son or daughter in adoption can go for adoption. Earlier, this was not existing. This is an amended provision. And the provision to Section 8 states that the married woman whose husband is living has the right to adopt a son or daughter with the consent of her husband, unless her husband has completely and finally renounced the world, or has ceased to be a Hindu, or has been declared by a court of competent jurisdiction to be of unsound mind. Similarly, in Section 9, we have the elements which describe the eligibility criteria for the persons capable of giving an adoption. And Section 10 talks about the persons who may be adopted. So who may be adopted? For being adopted, the child must be Hindu. And there is an age limit which is prescribed under Hindu Adoption and Maintenance Act 1956. The age limit is 15 years or below 15 years. The child must be unmarried, barring some customs. And then age bar, as I've already discussed with you. So therefore, we have to see that what is the eligibility criteria to be considered for adoption under Hindu Adoption and Maintenance Act 1956. Not all the children can be adopted or can be given in adoption under this particular Act of 1956. So moving further, we have other sections from Section 11 to Section 18, which are describing various aspects of adoption. For example, Section 11 is talking about other conditions which are required for valid adoption. Section 12 is talking about effect of adoption, which means that once when the child is adopted, all the ties from the natural or the biological family are severed. So therefore, the effect of adoption is not only on the family ties, but also it is reflected for further issues relating to property, relating to succession rights, relating to inheritance. So therefore, the effect of adoption has to be seen from the perspective of severance of ties from the biological family, as well as the property rights of the adoptive child. Then Section 13 is talking about right of adoptive parents to dispose of their property. Of course, we have some aspects related to will. If you will the property to the adoptive child, that is fine, that is acceptable. But then what the section is talking about is the section talking about immediate transfer of the property, or like, there is a process which is prescribed by the rules and regulations. So again, we have to think on these aspects, that how the question of property is to be dealt in cases of adoption, not only domestic adoption, but also international adoption. Also, Section 14 is talking about determination of adoptive mothers in certain cases. So where a Hindu who has a wife living adopts a child, she shall be deemed to be the adoptive mother. Next slide, please. Section 15 is talking about valid adoption once made shall not be cancelled. It means that once if the adoption is made, it is considered to be final in nature and it shall not be cancelled. I think, this is a problematic provision, because what if the child is transplanted or transferred in a wrong family? So I think this requires reconsideration. Then Section 16 is talking about presumption as to registered documents relating to adoption. So this is all about presumption, that it is presumed that those documents are right documents. The court shall presume that the adoption has been made in compliance with the provisions of this act, unless and until it is disproved. And then we have Section 17, which is talking about prohibition of certain payments. So we see that majorly it is from Section 5 to Section 17, the aspects of child adoption under Hindu Adoption and Maintenance Act 1956 have been covered extensively. Next is, how many types of adoption are there under JJ Act 2015? So as we have discussed, that there are two legislations. One is Hindu Adoption and Maintenance Act 1956 and the other legislation is JJ Act 2015. Now, Hindu Adoption Act is only talking about domestic adoption, that is in-country adoption, and that too only for Hindus. But JJ Act is talking about in-country adoption as well as inter-country adoption, and it is not limited to Hindus only. So therefore, it can be inferred that it is a step towards uniform civil code. Now, as you can see, in-country adoption means adoptions which are happening within the country, and it is governed by the respective laws, sometimes the personal laws of the respective parties. Inter-country adoption means when the adoption of a child is by a person of another country. So therefore, there is a foreign element involved in inter-country adoption or international adoption. And of course, we have seen other elements related to habitual residence and nationality and citizenship. These other aspects are also important in case of international adoption. And it is governed by Hague Convention on Protection of Children and Cooperation in Respect of Inter-Country Adoption, 1993. Moving further, what is the legal process for adoption under JJ Act 2015? I've tried to simplify this entire theoretical aspect. So you can see here that if it is in-country adoption of orphaned, abandoned, or surrendered children, then the process is that first, child should be declared legally free for adoption under Section 38 of the JJ Act 2015. And then prospective adoptive parents must register online on Carings, which is an online portal, and upload their documents, home study report, which is conducted by specialized adoption agency, medical examination report, and child study report well within time. And prospective adoptive parents are then provided by certain documents and the profile of children, and they are required to reserve the child within 48 hours. Then the last step here is acceptance of the child by the prospective adoptive parents, and then the child is taken for pre-adoption foster care. So therefore, petition is filed by specialized adoption agency in the court, which is disposed of in 60 days. After that, the court order birth certificate to be issued, and it is followed by post-adoption monitoring. So therefore, the role of the court is extremely important. And in all the cases, the court see that if best interest of the child is protected, then only adoption is okay. So in fact, like I think that with court orders, the process is becoming more streamlined. Further, there is a requirement to introduce post-adoption follow-up system in a very strong way, because as of now, the post-adoption follow-up is limited only up to 2 years. So therefore, these are some of the areas wherein we can improvise. Next slide, please. So JJ Act, interestingly, is covering in-country relative adoption also. So one category is in-country adoption of orphaned, abandoned, and surrendered children, and we have seen what are the steps. The second category here is that it is possible to have this process within families. So therefore, in-country relative adoption is also permissible as per JJ Act 2015. What is the process? The process is very interesting. One is that you are required to make registration on carings and upload all the relevant documents. Then District Child Protection Unit will verify the documents, and further you require the approval by SARA, and then you are required to file the application and obtain court orders. And this has to be done by prospective adoptive parents, keeping in mind the time frame. So these legislations have to be read in consonance with the regulations issued by Central Adoption Resource Authority, as well as the rules, because they are providing the exhaustive process. Now, when we are talking about in-country adoption, not only relative adoption is permitted, but also adoption by step-parent is permitted. And what is the process here? First is that you are required to take permission from Child Welfare Committee as per the schedule. Then upload all the relevant documents in carings, and initial approval is required from Central Adoption Resource Authority. And then you will file the application, obtain the court orders. But in all the three processes, you would find that the aspect of monitoring or post-adoption follow-up is very minimal. I request you to please change the slide. Next is inter-country adoption in India. The process of inter-country adoption of orphaned, abandoned, and surrendered children. So now that we have dealt with in-country adoption, we have seen the process, and also we must have analyzed that the process is quite simple in nature. But when it is coming to inter-country adoption, you must be seeing many boxes. It's because foreign element is involved, and therefore scrutinization of the documents is much more. The process is complex, no doubt, but it has been streamlined. There is further requirement to streamline the related processes. We are going to discuss all those. So what is the process as of now? The process is that first counseling and preparation of home study report of prospective adoptive parents by social worker of AF AA or central agency or Indian mission is there. Counseling is the requirement. One must know that what is the purpose of adoption, why foreign parents are interested to adopt from India. Then there is a requirement to prepare home study report. Then foreign adoption agency or the central agency or the Indian mission is required to look into further details of the child as well as of the prospective adoptive parents. Because whenever the foreign element is coming, there is a question of jurisdiction, there is a question of citizenship, there is a question of nationality, residence. Automatically, all these elements are attracted in the system. Next is registration of prospective adoptive parents in carings by AFAA or central agency or Indian mission. Then uploading of the documents, then initial approval by Central Adoption Resource Authority. Then we have the system of child referral and reservation through carings. So it is limited and a limited number of children are referred for these purposes. Then child matching by specialized adoption agency and acceptance by prospective adoptive parents. There is a requirement to obtain no objection certificate by Central Adoption Resource Authority. And then after that, adoptive children are given in pre-adoption foster care. Only few prospective adoptive parents exercise this option. So therefore, this is optional in nature, but there is an advantage. If you are putting the child in pre-adoption foster care, you would get to understand the child better and the requirements in better terms. Then court order, conformity certificate, passport and exit visa for the child. Then finally, child arrival, citizenship issues have to be looked upon. And then post-adoption follow-up in international adoption is for 2 years only. So this is the entire process of inter-country adoption of orphaned, abandoned, and surrendered children. So this category is different. Now, when we are moving towards process of inter-country relative adoption, the process is quite different because here we are talking about family to family transfer, but the character is international because the aspects of nationality, residence, citizenship are automatically attracted. So therefore, this is a much more simplified process. So first is home study report and registration of prospective adoptive parents, uploading of documents of prospective adoptive parents is required. Initial approval by Central Adoption Resource Authority is again needed. Verification by District Child Protection Unit and approval by SARA, State Adoption Resource Authority, is required. Filling of application and filing the application is at most needed. Obtaining of court order by prospective adoptive parents. And then after that, NOC should be issued by Central Adoption Resource Authority along with the conformity certificate, passport, and exit visa for the child. And then again, the aspects are similar: child arrival, citizenship, and post-adoption follow-up for 2 years. The only difference between the process of inter-country relative adoption and inter-country adoption related to orphan, abandoned, surrendered children is that in the former one, we are talking about family transfer, family to family transfer. And therefore, process of inter-country relative adoption is much more simpler in nature. I request you to please change the slide. So as you can see that these are some of the statistics, some important figures which you can see here from 2010 to 2021, 2022, you would see that there is a massive change in in-country adoption as well as inter-country adoption. In 2010, 5693 in-country adoptions took place, whereas 628 inter-country adoptions took place. And if you go to this phase, 2013-14, 2014-15, you would see that the number of adoptions declined somehow. What were the reasons? We have to analyze. So in 2015, we know that JJ Act, Juvenile Justice Care and Protection of Children Act 2015, was enacted. And after the enactment, you can see that there was further increment in adoption cases. So, with this statistics, we can analyze that how the act is performing and how it is serving the interest of the general public, of the common man. So, this statistics is again very important. And this has been taken from the official website of Central Adoption Resource Authority. I request you to please change the slide. So these are the figures which we have already discussed. Next slide, please. Now, let's talk about critical analysis of Hindu Adoption and Maintenance Act 1956. So we have discussed in detail the provisions related to Hindu adoption. So what are the criticisms and how we can improvise our systems? So first is that there is a limitation that only Hindu children can be adopted. Second is that issue of jurisdiction of the court. Also, we need to have more specialized courts, adoption cells in the family court. If we have such specialized courts and adoption cells, then the process will be streamlined and further. I believe that adoption will happen efficiently. There's a requirement to take consent of the child. There's a requirement to know the wishes of the child. So somehow this is missing in the present legislation. So in the times to come, it may be reconsidered. Also, we have to see that what are the age requirements, whether the age requirements are okay or they also need some modification, because as per Hindu Adoption and Maintenance Act is concerned, present age requirement is 15 years or below. But then in that case, we are not covering the children from 15 to 18 years. So there are different age requirements mentioned under Hindu Adoption and Maintenance Act 1956 and Juvenile Justice Care and Protection Act 2015, because as per HAMA, we know it is 15 years or below 15 years, but as per JJ Act 2015, it is up to 18 years. So then, there are other aspects also, like discrimination between a father or mother continuing to be a Hindu and a father or mother ceasing to be a Hindu under Section 9. So again, these aspects can be deliberated upon. A definition of child, how we can define the child and who can be falling within the category of child. So it has to be speculated. Then next is discrimination against the adopted child should be punishable. As of now, we do not have any provision which relates to discrimination. We know that adopted child is transferred from one family system to other family system, or it is coming from the orphanages or from other homes, maybe at times observation homes, special homes. So it is to be seen that, if they are adopted and if they are placed in the adoptive families, then they should not be discriminated. And therefore, I believe that, it would be better if some provision for punishing the discriminatory act should be introduced. It would be a better step. Adoption by unmarried persons, widow and divorcee, and their subsequent marriage. Again, this is a big issue. Adoption must be under the supervision of the court. Now, here the theoretical aspect is different, and in practice we have seen that adoption deed is always preferred, and not only signing of adoption deed but also registration is preferred. So therefore, in practice we have to see that how we can make the process of adoption more legitimized, because when it comes to adoption, if you see the old Hindu text, ancient text, you would find that it is simply giving and taking of child. So even like if a sanskar is performed, if a ceremony is performed to that effect, it is more than sufficient. If the child is given and taken in adoption, the process is complete then and there. But with the improvised court practice, we have now good systems. Now we are having adoption deeds, registration of adoption deeds, so that the systems can become more legitimate and strong. Now, coming to consent of a non-Hindu wife for giving the child in adoption. So it has to be seen that whether the consent should be considered as valid or invalid, how much weightage is to be given if the consent is coming from a non-Hindu wife for giving the child in adoption. So again, these are some of the areas which I believe can be worked upon and can be considered for further modifications and amendments. Then one suggestion is Hindu female may have a plurality of adopted sons and daughters. So therefore, adoption has to be seen in the light of all these situations. I request you to please change the slide. Then in this slide, I have covered the dimensions of conversion, customary laws, then unreasonable restrictions which are placed in section 11, age difference related conditions, then registration of adoption, and then cancellation of adoption if it is required, and controversy regarding reservation benefits for adopted child must be settled. So sometimes it happens that adoption takes place because of some reservation benefits. There have been cases. So we have to see that what is the purpose of adoption. If the purpose is to protect the best interest of the child, if the purpose is to give the child a good life, then yes, the purpose is good. But if the purpose is not related to giving or protecting the best interest of the child, then certainly it is a big question mark. So sometimes children are adopted, biological parents are giving their children to the adoptive parents in order to get reservation benefits for their children. There have been cases wherein children have been adopted in order to get reservation benefits. So therefore, even it is the responsibility of the court to see the purpose with which the adoption has taken place. Interestingly, when we are talking about age limit, an upper age limit must be fixed for the purpose for the persons who want to adopt a child. Liberal financial help should be given by the government in such cases. So adoption, by and large, is not only the right related to a child, but it is a human right. Now, coming to some of the suggestions for the better functioning of the inter-country adoption law, that is international adoption law under JJ Act 2015. So one is that inter-country adoption should be handled with great caution, because we understand that issues of child trafficking, abduction, citizenship, nationality, residence are automatically coming into picture. So therefore, it should be streamlined. It should be handled with utmost caution. Penal offenses for the agencies who are taking bribe or who are getting involved in unnecessary financial transactions. Then licensing regime should be made stricter. Awareness program for the poor, needy women and parents should be organized in good number. Moving further, we see that there is a requirement to have expert counseling by psychologists, social workers, and legal practitioners. Bilateral ties with the receiving countries must be mandatorily checked before initiating the adoption procedure. Central Adoption Resource Authority and State Adoption Resource Authority must play an active role in adoption cases. Then all sort of financial transactions should be scrapped. Further, it should be encouraged if the adoptive child wants to know his or her origin, his or her roots. So therefore, our processes of international adoption should facilitate root search by adoptive children. And this can be only done when we are maintaining proper records of international adoption, and on filing an application, such records are becoming available to the person who is asking for those records. So moving to post-adoption services, there is a requirement that it should be a continuing one. Monitoring and follow-up of adoption is required rigorously, and it should be a continuing one. Next is adoption of children with special needs should be evaluated on a systematic and regular basis. Also, it is to be seen in the light of the domestic laws of the respective nation that if adoption by same-sex couples and transgenders are allowed or not. There is a requirement to see the consent, to assess if the consent taken or given is an informed consent or not. So therefore, as private international lawyers, I believe that these elements become extremely important whenever we are taking up these cases of adoption. So these are certain developments in the recent past. As you can see, that Amendment Act of 2021 has been introduced with rules 2022 and adoption regulations 2022. So further, these regulations and rules signify that we are moving towards a streamlined process for international as well as in-country adoption in India. Now, coming to the next part, which is laws in other South Asian nations. So we are going to see that what are the laws for adoption in other South Asian countries. So first, let's talk about Bangladesh. As you can see that Bangladesh does not allow full adoptions, and there is no formal adoption agency in the country. Therefore, foreign resided Bangladeshi citizens considering adoption of Bangladeshi children must obtain guardianship from a Bangladeshi court and subsequently adopt the child in abroad. Now, we need to consider here that adoption, guardianship, and foster care, they all are different concepts. When we are talking about adoption, we are talking about severance of the ties from the biological family, and the child is permanently transferred to the adoptive family. Also, adoption by and large is of permanent nature. But when we are talking about guardianship, it does not indicate the right to property. It does not indicate the right to have a family permanently. And also, the same is applicable in foster care. So therefore, guardianship and foster care, they are providing temporary support to the children who are looking for families, and they are not the permanent solutions. So as we can see here in the case of Bangladesh, it is establishing a process for guardianship and not for adoption. And we know that guardianship is different from adoption. So here guardians are appointed, and they are responsible to look after the child. But the rights from the adoptive parents are different from that of the guardian. I request you to please move the slide. Next is legal guardianship, as what we have discussed. So prospective adoptive parents can apply for legal guardianship in Bangladesh, and the process is that they need to submit an application to the family court in the child's district of residence. And there is a requirement to meet the eligibility criteria. Also, there is a requirement to apply for an adoption or immigrant visa for the child. So as we can see here that as per the system of Bangladesh, it is the legal guardianship which is protected. I request you to please move the slide. This is again the process for legal guardianship in Bangladesh. It includes review of the proposed guardian's character and capacity by the family court, filing the guardianship petition with court fee, providing documents such as the child's birth certificate. Then these are certain adoption restrictions that foreigners are not allowed to be legal guardians of children. Simple, conditional, or limited adoptions are not considered valid. And in majority of the Islamic nations, we have seen that Muslim law does not have provisions for adopting a child. So adoption is not legally available for Muslims. Now, coming to Pakistan, as what we have discussed, that in majority of the Islamic nations, we find that adoption is not considered. And Pakistan does not have a law that specifically addresses adoption. So there are no requirements for age, residency, or marriage. So basically, in Islamic nations, we find that foster care is given much more importance over adoption. And it has religious significance also. So here also in Pakistan, as you can see, instead, adoption is handled through guardianship, which provides care for children without changing their lineage. So some of the important elements here are guardianship, non-citizens. So guardianship, under this, we can see adoption is handled through guardianship, which is done by applying provisions of the Guardians and Wards Act. And this act prohibits non-citizens from adopting a child. So here, more emphasis is on guardianship and foster care and not on adoption. I request you to please change the slide. Next is Maldives, as what is inferred, that the law does not allow adoption. And therefore, in all the Islamic nations, we are analyzing that it is guardianship and foster care which is preferred over adoption. So in Maldives also, long-term guardianship is the only alternative to adoption, and it is only available to Maldivian nationals. And they have a system of foster care, which is again different from adoption. Children in foster care are not legally adopted, and foster parents are usually temporary legal guardians until the child is 18. So therefore, we have to analyze that the term adoption is different from foster care and also guardianship, and all have different legal implications and repercussions. So the purpose of foster care is to provide a safe and nurturing environment for children who are unable to live with their biological parents. But again, in guardianship and foster care, there are no provisions relating to property rights, relating to further well-being of the child. And these concepts are more temporary in nature, whereas adoption, on the other hand, is giving some sort of permanency in the child's life. Next slide, please. In Nepal, as you can see, that inter-country adoption or international adoption is available for relinquished children. I'm not going to discuss details. You can always see these slides. I request the organizer to please share the slides also. Next slide, please. Yes. So next slide. Yes. So this is important that in 2019, there was a change in international adoption. And this is because of the situation. So Nepal's Inter-Country Adoption Management Development Board under the Ministry of Women, Children and Social Welfare was disbanded in July 2019. So as of January 2020, international adoptions from Nepal are on hold due to the disbandment of Inter-Country Adoption Management Development Board in 2019. But in cases of domestic adoption, the Ministry of Women, Children and Senior Citizens in Nepal can be further consulted for related information on local adoption procedures. Next is Sri Lanka. As you can see, interestingly, Sri Lanka is a party to Hague Convention on Protection of Children in Cooperation, 1993. Therefore, if it is a party, it has to be analyzed that whether the laws are enacted as per the provisions of Hague Convention or not. So the procedures are quite streamlined as far as Sri Lanka is concerned. Next slide, please. Coming to Afghanistan, it is not a party to Hague Convention, 1993. And again, as we have seen, that in a majority of the Islamic nations, adoption as a concept is not preferred. It is the foster care and guardianship which is given importance. Coming to Bhutan. So here only foreign nationals from countries with a Bhutanese embassy, consulate mission or designated representative can apply. Inter-country adoption is only considered when there are no suitable adoptive parents in Bhutan. The process, you can see that the National Commission for Women and Children processes adoption applications, and this process includes submitting an application to NCWC, waiting for the approval or rejection, and submitting the documents if it is approved, attending pre-adoption counseling, filing the application with the court, attending the court hearing, submitting a document, related document, and copy of adoption order to NCWC. Next slide, please. All right. Before I conclude and give my suggestions, I request the participants to please raise questions if you have any.
So I request everyone to kindly share any questions that you may have. In the meanwhile, I'll just take a few questions, whatever I have received. So, ma'am, first question is with respect to the stats which you showed, and it's visible that there has been a standard decline in the rate of adoptions. Is there any specific reason, or very unique to see that it was very high towards when the start started around 2010 and towards 2019, I think, and now also globally, I think it has just gone down.
Yes, it's a very good observation. And logically, if we think science has advanced, and now we have many more alternatives which are introduced for adoption, like surrogacy, and with the advancement of science, we have seen that infertility treatments are available. So therefore, there is a slight decline in adoption cases because of the modern advancements in science. Um, and also, I think that, from 2014, 15 onwards, again, the number of cases have risen. So maybe because like now the processes are comparatively streamlined. So therefore, again, the faith is reposed in our systems, and therefore again international adoption is on rise. But certainly there are now more alternatives available for adoption. That's why uh, adoptive parents, or the prospective parents are taking different routes, not adoption but other routes of surrogacy, or other options which are available.
Thank you, ma'am. Ma'am, I also understand you mentioned that there was. May I end the slideshow?
Yes, yes. So the last slide covers suggestions and conclusion, and I want to discuss that after receiving suggestions from the participants as well.
Ma'am, I think you can conclude this, then we'll just come to the question and answer because few questions I've received, I'll just share with you. And most of the doubts it was so elaborate that you actually covered most of the questions, which whatever I've received at least.
All right, okay.
So I'll just share.
All right, if you can move to the last slide. Yeah, so it is conclusion and suggestion. So basically, when we are talking about the concept of adoption, adoption is based on the aspect of providing home to the homeless and child to the childless. And now it is based on the philosophy of child welfare. So the process has to be child centric, not parent centric. It is good if we are striking the balance between parent centric adoption and child centric adoption, but it is always better if the system and the process is child centric, because it includes inherent elements of child welfare in such processes. So therefore, international adoption should be encouraged with appropriate protections against abuses. And there is a need to have stringent legislations, particularly on international adoptions, which are well aligned with international law, to ensure that children are not wrongfully taken from their birth parents, biological parents, or transferred to foreign lands in which they will be mistreated or exploited. Bilateral ties with the receiving countries must be mandatorily checked before initiating the adoption procedure. And it is to be ensured that financial transaction of all sort should be scrapped. Law should also guarantee children the fundamental right to grow up in a nurturing environment so that the best interests of the child are served. As already we have discussed about root search by adoptive children should be facilitated. Then adoption of children with special needs should also be evaluated on systematic and regular basis. Time has come wherein we should think on the question of adoption by same-sex couples and transgenders. And also there is a requirement to see if the consent which has been obtained is informed or uninformed. So these are some of my suggestions to improvise our international adoption systems. And I think that, with the coming times, we can certainly come with better solutions.
Ma'am, thank you so much. It
Thank
was
you.
actually very, very enlightening, and I'm absolutely certain that anyone who has had the opportunity of uh, being through this session would have definitely learned a lot much more about the law of adoption. So I request everyone, please, whatever your thoughts and questions are, I request you to kindly ask, ma'am. You can raise your hand or you can share your question in the chat box, but please feel free as per your convenience. In the meanwhile, ma'am, I'll just ask one question which I've received from Mr. Kartikeya Kakat. Kartikeya ji, please, you ask, sir.
Good evening, ma'am. Good evening, sir.
Good evening,
Good
Kartikeya ji.
evening.
आप पूछो, आप जो आपका सवाल है ना.
Ma'am, my question is now, what is the impact of international adoption on a child nationality?
All right. It's a very good question. You are talking about the impact of international adoption on child's nationality. So, as what we have discussed, the process of international adoption is a bit more complex as compared to domestic adoption. And once the child is adopted as per the process of international adoption, and once when the child is in the country of adoptive parents, foreign adoptive parents, then afterwards they have to file the application for citizenship. So, the process is becoming complex because it is to be ensured that, if the child is leaving the country and reaching the country of foreign adoptive parents, then they should get the citizenship of that particular country. And, they should, in the process, they should not be rendered homeless or landless.
Yes,
So,
sir.
this is a very crucial aspect, and it can be resolved with the help of bilateral ties which are existing between different nations, and by properly following the procedures mentioned in the respective domestic legislations.
Yes, sir.
Thank you for this question. Quite interesting.
Thank you so much, ma'am. Thank you so much, sir.
Thank you.
Thank you, Kartikeya ji. So, ma'am, another very interesting point that you raised was with respect to the ART and the IVF structure which is there. There's also a petition pending in the Supreme Court currently with respect to challenges to these. So, I had the good fortune of having some sort of an interaction in that matter as well. So, there is a upper age limit in that couples with about 55 years, that's the top ceiling for that. So I think you suggested something similar, that for adoptions also there should be a ceiling.
Yes. So basically, my point is that in adoption, uh, what is written in the statutes, that as per HAMA, children up to 15 years, that is 15 years or below 15 years, are available for adoption, but it is silent on the children who are coming in between 15 to 18 years. So what will happen to them? As far as JJ Act is concerned, it is covering children up to 18 years, that is 18 years and below 18 years. So I was talking about that age discrepancy which is existing between these two legislations.
Certainly, ma'am. So, ma'am, it's been a very, how do I say, very interesting and very eventful session, this learning process with you. And I'm absolutely certain that there's been a lot to learn for everyone, and we've only greatly benefited through this session. So, deepest gratitude to you, and thank you so much for picking such a unique topic on which I think a lot of curiosity definitely is there, and absolutely people don't have a lot of good information, valuable and reliable, which from where they can at least you, ma'am. I really appreciate how you broke down the entire processes, and anyone I think who can just go through the slides also. I'll share the slides with the group as well, so anyone who can just go through that also, I think that they can greatly benefit, but at least in understanding the basic process of it. And obviously, they'll require a lot of work and commitment if they really want to go ahead with adoption. Then definitely there's a lot of work that people will have to do. But
Certainly,
yeah,
I believe that there is a requirement to encourage this concept, because when we are looking at the child, we have to see that what is the well-being of the child. So adoption is not limited only to family adoption. I think that is the safest way of adopting a child, family to family transfer, wherein you know about the details of the child, the lineage of the child. But here more concern is about orphaned, abandoned, and surrendered children. They are really in requirement of families wherein their overall well-being is ensured. So when we talk about child development, certainly we have to look into the aspects of child adoption, because if they are placed in good families, then the chances are that their holistic development is ensured. So that is the noble purpose, noble aim behind adoption. And I think that, this concept has to be encouraged and it will grow in number.
Ma'am, just one other thing which just intrigued my curiosity. Actually, I have a lot of other questions if you would.
Yes, please go ahead.
I'll ask a few randomly only.
Yes.
So one is, ma'am, you mentioned a very important topic of children who are orphaned, abandoned, or surrendered. So for such children, is there any form of a statistic where all of these information is collated, collected? For how many children
Yes.
are there such in such categories?
Okay, so if you are talking specifically for India, then I believe that a lot of groundwork is required in such cases, because there are a lot of orphaned, abandoned, and surrendered children, but they will become eligible for adoption only when they are declared to be available for adoption. That is the problem. So sometimes many of us might have confronted this situation that we see a lot of children on traffic signals. So whenever I see those children, I always think that, is there a way to provide better lives to such children? And when it comes to child, of course, they didn't do any wrong. There is no fault of theirs. And they're suffering because they don't know what is happening to them, what wrong is happening. So again, when we are looking at adoption, that's why I said that we have to study this particular topic. We have to discuss this topic from transdisciplinary perspective, not only adoption from the angle of international law, not only adoption from the angle of family law, but also criminal law. We are talking about discrimination. What will happen if children are adopted and then later on they are discriminated by the adoptive parents? So how these situations have to be dealt with? What will happen if they are adopted by foreign parents and then they are rendered homeless in foreign lands? So the same question was raised in Lakshmikant Pandey's case. And this has led to streamlining the process of adoption, international adoption in 1984. And still, a lot has to be done in this particular area. So I urge all the advocates, all the lawyers, all the law students who are listening to this lecture to at least give a thought that what solution we can propose to this existing problem and how we can come out of it. Because children are considered to be an important national asset. Growth of a child is directly related to the growth of the nation. And that's why this topic is extremely important and significant.
Certainly, ma'am. Certainly. I really appreciate your enthusiasm for this topic, and I'm absolutely hopeful that your request right now, which you just made, that more people will definitely be considerate and give it a good thought. So, ma'am, another thing
Thank you so much.
which I found very intriguing in your presentation was that where you mentioned that places like what I could understand is that Bangladesh, then Pakistan, Afghanistan. These three countries, they don't have any laws with respect to any kind of adoption. And what you also mentioned apparently that the Muslim law does not have any kind of provisions for adoption. So, ma'am, two things. One, what happens to a child, or probably if a Muslim couple wants to adopt a child, then what is it, what do they, what are the things that they have to possibly do in India? Now I'm asking, is it permissible in India, whether if they can? And what happens to their like an adopted child's religion in any respect? Like supposedly in Hindu HMA, it's quite clear, I think. But under the JJ Act, what happens to that? Does the child get an option, or is it that they necessarily have to look in towards, for the adopt the religion of the adoptive parent?
Okay, again, a very interesting question. So first of all, when we are talking about Bangladesh, as what we have discussed, the process, so their legal guardianship is available, adoption to a limited extent, but major focus is on legal guardianship. And in all other Islamic nations, as what we have seen, guardianship and foster care are available and not adoption. Now, coming to your question, as far as India is concerned, in 2014, we have an interesting judgment by the Honorable Supreme Court, Shabnam Hashmi versus Union of India. And in that, the same issue was raised, that suppose if Muslim parents want to adopt the child, then how they will go for adoption? Because Muslim law forbids adoption. Muslim law is talking about foster care and guardianship, but not adoption. So what is the solution available for adoption as far as Muslim couples are concerned? So in Shabnam Hashmi versus Union of India 2014, it was stated by the Honorable Supreme Court that adoption is a human right, and such right is not restricted by any religion. And if the couple wants to adopt, they can very well adopt it. And I think, this has further led to streamlining the process. And we have in 2015 Juvenile Justice Act. And in a way, it is a step towards Uniform Civil Code. And now all can adopt child under 2015 Act. Muslims, Christians, Parsis, Sikhs, Hindus, all can adopt. So therefore, this complexity has been dealt in 2014 itself. So first the judgment and then the 2015 Act. So of course, as far as other nations, other South Asian nations are concerned, they are especially Pakistan, Afghanistan, Maldives, their system is focusing on foster care and guardianship. And we know that there are different legal implications when it is foster care, when it is adoption, and when it is guardianship. So, it is not only about giving home to the homeless, but also it is about providing comfort, well-being, to look at the well-being of such children.
Certainly, ma'am. It's a very pragmatic overview that we've received, and I'm certain that many people will find it beneficial. Just one final question, ma'am, that will come towards. So, ma'am, you elaborated and narrated very detailed aspects of the proper adoption procedures as per law. Whereas we see in India a lot of times there are a lot of people who, in general, who they just find probably a child and they keep, let's say, an orphan child, they find and they keep him with themselves over a period of time, let's say about 10, 15, 20 years. Uh, and after that, but there is no official adoption paperwork or any kind of documentation that has happened. So, in that stage, at the later stage, can that child possibly claim some sort of rights in probably the inheritance or the assets of that family, or can that, or what are the kind of things that that child can possibly get, and where is that child situated in law?
Okay, again, it's a very interesting question because when we are talking about such adoptive children, the problem here is that if there is no adoption deed, if there is no valid proof of adoption, then how we are going to justify the entire process? Because court believes evidence, and what is the evidence? And is the ceremony of giving and taking child sufficient enough to provide evidence? Are the photographs sufficient enough to provide evidence? So in some cases, we have seen that court has considered those photographs as evidence, but it is always better to have a registered adoption deed in order to explain that yes, adoption process has taken place legally. So again, this is, I think, this problem is more domestic in nature, and with times to come, court practice will also change, and then, we will focus more on the documentation when it comes to adoption. As far as the property rights are concerned, again, it depends on the family arrangement, and the adoptive parents can always will their property to the adoptive child. As far as the right of the adoptive child is concerned, he has to prove before the court that he is an adoptive child, and how he will prove. So we have already discussed about it.
Certainly, ma'am. It's just very enlightening and how do I say, very, very thought-provoking, this entire conversation with you today. And I'm hopeful that my only hope is that at least one child may find a house with this session and interaction that we've done, at least with some convenience. And ma'am, deepest gratitude to you. Thank you so much for taking your time out and with whatever changes also we had to do with the time. So thank you so much to everyone who's joined us and who has been with us so far. So there's one thing which ma'am had asked me for, which I think we've absolutely failed. One part which we have failed at is asking for the feedback. We've not shared the feedback form, and the class is about to get over. So anyone, please, if you have some kind of feedback, I request, please just share right now. Right, let us know if if you whatever you felt about the class, or probably just message me later on. So we'll get that. I'll communicate it to ma'am. So ma'am, it's very enlightening. We received one session. Thank you so much, sir.
Thank you very much for inviting me to deliver this talk. And I'm extremely thankful to your esteemed organization and to all the participants who are listening. And it was a wonderful experience. And I must admit that my knowledge has also enhanced because of these interactions, because of the questions you have raised. So it was really interesting to note your observations and questions. Thank you, one and all.
Deeply, deeply grateful, ma'am. Deeply grateful to you, and thank you so much to everyone who has joined us, who's
Thank you,
participated.
ma'am, for enlightening us on this
Thank,
show.
thank you, Dhananjay ji. Thank you so much.
Thank
And
you.
so, ma'am, so again, so there will be some feedback. Hopefully, we'll try to gather later on. And in the
All
meanwhile,
right.
I also please, Dhananjay ji.
Thank you so much, ma'am. Thank you so much, sir, for this.
Thank you,
Thank you.
Karthikeya ji. It's so wonderful कि आपके सवाल हमेशा बड़े relevant होते हैं. Really appreciate that.
Thank you so much.
जी, Dhananjay ji, please, you were saying something.
I would also
Please,
I
ma'am,
would
please.
also like to add over here that
Certainly.
okay, my name is Pooja Talim and I'm a student of SYLLB. Of course, I
Wonderful.
have started my education after a very long break. And this session was definitely very enlightening. There is a lot which I have learned from a perspective of a student. Of course, as someone who has majored or rather attained majority age a very long time back, while we were reading about these laws and as they were happening in the newspapers over the years. But then again, the other legal implications and how would the laws work internationally, this session has definitely given us, or rather, at least me, a very good point of view, and of course, a very good set of sentences as well as notes to pass on to my seniors as well as my classmates in college. So, thank you so much. Thank you.
Ma'am, thank you so much. And I request you kindly, please also share the class video also with them. They will get to learn the entire thing. And please, just let
I will
people know
most
this.
certainly do that.
So, ma'am, this is a free legal literacy initiative. We're trying to get people to talk about laws so that at least that problem of undocumented adoption does not happen. At least with the help of this video today, people know what is the
Yes,
process of going through it, and people can do better. But at the same time, ma'am, please just share with all of your. If you're studying still, then that's obviously a blessing. So please just share with your
yes,
classmates, with other groups, and everyone. So thank you so much.
certainly.
Thank you for
Thank
your
you.
appreciation and wish you all the best.
Thank you so much, madam.
Best
You
wishes.
have a
Absolutely.
very pleasant evening.
Thank
Thank
you.
you.
Same to you.
So, ma'am, again, so I think little feedback we've
Yeah,
received. Yeah, but this is
certainly,
better. Yeah,
certainly.
if people have told
So
directly, that's better.
thank
So
you
thank
one
you
and
so much.
all. Yeah,
Yeah, ma'am, thank you so much. So I request everyone kindly, if you're watching on YouTube, then please you've stayed with us for so long. So kindly subscribe, like, share. It's absolutely free. We don't have a lot of resources, and neither do we have the capacity to promote. So, you will only have to help us and assist us. If you think that there is some merit in what we are doing, then please just spread the word. So, Daksha ma'am, I also request you to kindly आपके जितने college के जो बच्चे हैं, उन सब में भी, if it can just, go out to them that there is something of this sort happening. So,
certainly.
we have very good faculty coming from across India, ma'am, speaking on various and very interesting topics on laws. So how you chose, so everyone chooses their own topic. So it's very unique actually. And the kind of personal insights and ideas that we get. So it's really I have personally benefited a lot. I think after college also my learning has continued. And I request everyone, please just take that time out to follow it. If you're in the legal profession, then it's most important to continue the learning. So with that, ma'am, thank you so much. So kind of you.
Thank
And
you, everyone. Have a good night. Bye. Take care.
ma'am, I request your permission to end the class.
Yes.
All right. Thank you.